Hello, welcome to this webinar. We will start in a few minutes. Hello, Yasmin.
Hello, Fanny.
Hello, all. We are going to start soon this webinar. People are joining, so welcome to all. Good morning, good afternoon. Welcome to this webinar. I am Fanny Dastuk, the Director General of CICA, the Global Confederation of Contractors. Welcome to this webinar again. As you may know, CICA and DRBF have increased their collaboration the past 2 years with joint initiatives, including joint webinars. So as a reminder, in our first webinar, we made a general introduction about dispute boards. In a second webinar, we addressed some hot topics and key issues with regard to the dispute board appointment processes. We then organized a session on best practices for dispute avoidance and resolution in the CICA EIC conference last November in person in Paris. This webinar today aims to present the joint paper of CICA, EIC, the European International Contractors, and DRBF to address practical challenges in dispute board implementation with our recommendations for improvements. So just for the context, we decided to write this paper during a joint mission we did to Washington to enrich our discussion about dispute boards with the financing institutions. And the idea was really, at their request, to provide them with concrete and practical recommendations for implementation. So we already had the opportunity to organize such a webinar with the MDB community earlier this year, and we are very pleased to present it to you today. So now we'll turn to Yasmin, whom I am very glad to co-host this webinar with. Thank you, Yasmin.
Well, Fanny, the pleasure is mine, and thank you for the introduction. It was great as always. This is Yasemin Çetinel. For those who may not know me, I'm one of the former presidents of Region 2 Board of Directors for DRBF. We are very, very pleased to have you in our audience today. And we are equally pleased in relation with our joint collaboration with CICA over the last couple of years. We have done great things, and we will hopefully make some further initiatives together. So Fanny explained us what we did so far in terms of joint webinar initiatives, and I would like to briefly mention what we have in our schedule ahead, in our to-do list. So as Fanny mentioned, this webinar is really for launching the joint paper that we have the drafters here, the main contributors to the paper. And one of the next subjects we will be elaborating in our next webinars will be developments, news, and perception on the dispute board concept from MENA region, because as you may all know, the region booms currently in terms of construction sector. There are a lot of ambitious and very sizable projects. And we will accordingly observe and elaborate Saudi Arabia's new contracts, as well as Abu Dhabi Infrastructure Center's new efforts in adopting the dispute board concept in the region. Similarly, in another webinar, we aim to organize and treat the topic of the position of dispute boards, if any, within the concept of rated criteria principles, which is also another very hot topic in our sector. We really hope you will enjoy this session, and please do follow our news and contribute and join our events whenever possible. Without further ado, I would like to proceed with our panel. And as stated, this webinar's core issue is the joint paper we drafted as CICA, EIC, and DRBF and we provided some recommendations for a more efficient dispute board concept all around the world, basically. To that end, Fanny, shall we start introducing our panelists? Shall I give the floor to you?
Yes, thank you, Yasmin. Maybe I will just add that you will have the opportunity to be active in this webinar, and you can type your questions in the chat during the presentation, and we will answer the questions after the presentations of the speakers. So our first guest today is Jeremy Glover, DRBF past president of the Executive Board of Directors. So Jeremy is a partner at Fenwick Elliott LLP, an accredited adjudicator and member of the CICA adjudication subcommittee. Jeremy is the co-author of Understanding the FIDIC Red and Yellow Book, a close-by-close commentary, the third edition of which was published in 2018, and lead editor of Building Contract Disputes, Practice and Precedents. Jeremy is a member of the Board of Examiners on the Construction Law MSc program at King's College London, and also teaches on the MSc Building Information Modeling Management program at Middlesex University. Yasmin, if you can introduce Nabil now.
Yes, please. We will, of course, give the floor to Jeremy very shortly, but let me introduce the other panelist, Mr. Nabil Kokar. Nabil is a consultant for construction industry and advising on the strategic development of contract management, legal activities, contract management, claims-related issues, international projects, dispute wars, dispute avoidance, arbitration, ADR, and digitalization. He is a member of the Chartered Institute of Arbitrators and a long-standing member of the DRBF. Nabil is further currently a member of two FIDIC contracts committee task groups, the one with development and publication of an EPCM form of contract, and another one on the development of flowcharts for the process and procedures within the 2017 FIDIC suites of contracts. He was a friendly reviewer of the 2017 FIDIC suite, and he sits on the EIC Working Group Contract Conditions.
Thank you, Yasmin. And last but not least, Richard Touroud, FNTP, French Federation of Contractors, Director of International Affairs. So after being the International Legal Director in prominent international construction companies, in May 2018, Richard became Director of International Affairs at the French Federation of Public Works and CEO of the Syndicat des Entrepreneurs Français Internationaux. He was a lecturer at the University of Tours, Advanced LLM program in Foreign Trade Law of the Law Faculty from 1984 to 2017. He is also a member of the Board of Directors of MEDEF International, Vice Chair of the Development Committee of the BIAC, Business at OECD, and Chairman of the Collège des acteurs économiques of the Conseil national du développement et de la solidarité internationale. So we have three great speakers today, and we will now turn to our panel. So Jeremy will make the first presentation about the paper. Thank you, Jeremy.
That's brilliant. Thank you both very much, and thank you all very much for joining us today. I think what I'd like to do today is talk a little bit about dispute boards and to add a little bit to the comments that Fanny and Yasmin have already made about how this joint CICA EIC DRBF paper came about. I'm sure you're all very familiar with the concept of the dispute board in 2025. Dispute boards, I suppose, have two roles. The more familiar one is the dispute resolution role, resolving claims in real time, where the dispute board delivers a decision or a recommendation on a formal dispute at the request of one party. But perhaps the increasingly more important role of the dispute board is the dispute avoidance role, where, as the name suggests, the dispute board is actively trying to work with the parties to avoid potential disputes or claims moving to the dispute arena. And I think potentially, as we'll see over the next 45 minutes or so, dispute boards can add great value to any project. And so when it comes to the position paper, one of the things that I think we all found, and as Fanny said, we found through our discussions with some of the financing institutions, is that while the track record of dispute boards is solid, dispute boards aren't always implemented. So what EIC and CICA and the DRBF, what we tried to do, we tried to consider some of the practical challenges that are faced by dispute boards. And then we tried to put forward some potential solutions. And when doing that, we discussed this with users, owners, and some of the development banks and financing institutions. And that's something that Nabil and Richard are going to be talking about in a few minutes. One thing I wondered is what we mean by saying that the track record of dispute boards is solid. Something that's solid is something which is hard or firm. But I think in this context, it's something a little bit more. It means something that's reliable, strong, based on firm foundations. And so when we say solid, we mean good. Perhaps we mean better than good, as some of the research will show. And 2025 marks the 50th anniversary of the first dispute board. It was a dispute board on a tunneling project, the Eisenhower Tunnel in Colorado in the United States. And the first bore of that tunnel was a total disaster. There were huge claims, some 50 million US dollars. And remember, that's 50 years ago. So it's a much more significant amount today. And what the parties were determined to do was to do something different, not let that happen again. And so they settled on a dispute board, 2 engineers and 1 lawyer, who could make non-binding recommendations, which could promote a settlement at job level. And one of the members of the dispute board wrote many years later that the biggest problem that the board has is that they went along for over 2 years with no problems at all. Now, of course, it wasn't just the appointment of the dispute board that brought about the changes. The parties wanted to change the way they acted. But it does seem very clear that the presence of the board at regular meetings meant that the parties were able to discuss issues amongst themselves or discuss the issues with the board and actually prevent disputes from arising. Now, that's dispute avoidance in action, really. There were a couple of small claims at the end, but it was a complete turnaround. And the main reason for that was the introduction of the dispute board. And what we're finding today is that in some areas, governments are recognizing the benefits of dispute boards, and they're introducing the concept of dispute boards in legislation. A good example of this is Peru, where the NEC3 contracts were modified to replace adjudication with dispute boards for some stadia on the Pan American Games. Now, the dispute boards were so successful that the Peruvian government modified their state procurement law to make dispute boards mandatory for resolving disputes in all public construction projects with a value of over $5 million US. And looking around globally, there are other countries which are following suit or implementing dispute boards in their own way. Indonesia, Honduras, and Brazil. And there are others that are also looking to introduce some form of mandatory use of dispute boards. In the UK, dispute boards are referred to in the government procurement book. The government's got a list of procurement rules and guidance what parties should be doing, and dispute boards are one of the options there for dispute avoidance. So we're seeing the dispute board concept being adopted by states. But in a sense, this is anecdotal evidence. What about cold, hard facts? Well, Florida, the Florida Department of Transport, 2013, they had 750 projects with a dispute board, and they carried out an analysis of projects where there was a dispute and projects where there was no dispute board. Now, where there was a dispute board, there was on average a cost overrun of 12.1%. With a dispute board, the cost overrun was 1.8%. Similarly, with time overruns, where there was no dispute board, it was about 20%, and it was less when there was dispute board. The result was that Florida decided to use the process for almost all of their contracts, and that was some 15, 20 years ago, and that is the position today. At the end of last year, King's College London produced a report on the use of dispute boards, an international survey into the use of dispute boards. When the survey was launched, Vivian Ramsey said that the report has allowed reliable data to be collected on all the topics about dispute boards, on which there was until now, with few exceptions, only anecdotal evidence. And you can see from the information on the slides that over 4,000 dispute boards were reported. And information came in from dispute board members, finance institutions, nominating institutions, as well as users, contractors, owners, and others. So what did the survey find? Do dispute boards work? Well, one way of testing is how often are dispute board decisions referred to litigation or arbitration. According to King's College London, on over 2/3 of the time, dispute board decisions weren't referred to arbitration and litigation at all. And if they were referred to litigation or arbitration, how often were those decisions reversed? The answer, according to King's College London, was rarely or never. And in this, the King's College research actually mirrored some earlier research that had been carried out by the DRBF. This was about 2018, so 5 years or so before the King's College research. And so when it came to dispute avoidance, the research showed that there were 337 recommendations, and of those, only 7%, only 23, moved forward to a formal referral. So by adopting dispute avoidance, the parties avoided a formal dispute. When it came to formal decisions, a slightly smaller survey, 512 decisions, of those, only 6%, only 32 were referred to arbitration. And of those, only 7, so 7 decisions were actually overturned. So that's 1.37 of all the decisions were actually overturned. So I think that's good evidence that dispute boards do actually work. And what about the cost? Well, looking at the percentage cost of the total cost of a project, King's reckoned that the cost of a dispute board was between 0.5 and 1%. Again, that mirrors DRBF research of 0.2 to 0.6% and is actually higher than the Florida Department of Transport research, which had dispute boards coming out at 0.1% of the total cost of the project. And I've been talking about dispute avoidance and the importance of dispute avoidance. King's found that dispute avoidance measures were adopted on about half of the time, 25% always, 25% very often. But I think much more significantly is what were the results of the adoption of the dispute avoidance measures. 45% of the time, the dispute was completely avoided. 40% of the time, the scope significantly reduced. And even where the scope was only marginally reduced, we were still able to lessen the issues that were in dispute between the parties, which enabled the parties to move forward in a more positive way. And that mirrors again the research from the DRBF, which shows here immense party satisfaction where dispute avoidance is actually being adopted. So I think from the brief research that I've had time to show you this afternoon, it's fairly clear that dispute boards do work. And I suppose that does, to some degree, beg the question about why there was a need for this paper in the first place. And one of the other interesting things that we found when we read the King's College London research was that a number of entities and all the funders indicated that they had a rule or policy for including a dispute board in all or certain of the projects in which they were involved. But although they had this rule, they all reported on many, many occasions that although the inclusion of a dispute board was discussed at the procurement stage, either the owners or the contractors or collectively, there was a decision not to include it. And that is really the genesis of this paper. When there were the discussions which Fanny and Yasmin have talked about in Washington with some of the funding institutions, the questions were really, well, why is this so? And what can be done? Why, in light of the anecdotal and the statistical evidence, which shows that dispute boards do work, and by work, I mean they result in a significant reduction in disputes, which means parties can are much freer to carry on and do what they actually want to do, which is finish the project to budget and on time. So what everyone did, they considered what some of the challenges were, and then thought was given within the DRBF, EIC, and CICA to how those challenges could be addressed. And that's the issues which Nabil and Richard are going to talk about now. They're going to highlight some of the points from the paper, the challenges, and also the ways that you can work around those challenges. So that's all I wanted to say for today. I'd like to pass on to my colleagues for a discussion of some of the issues that you can find in the paper.
Thank you, Jeremy, for the presentation of the benefits of the dispute boards and the results of the survey of King's College. Now we will turn to Nabil, who will share the first set of recommendations and the perspective of the contractor before hearing Richard. So Nabil?
Thank you very much, Fanny. I hope that you can hear me. We had some technical issues earlier, but I think we've resolved those now. Yasmin, thank you very much for the gracious introduction. And Jeremy, thank you so much for summarizing the effectiveness of dispute boards. And as you've highlighted, the track record for their use is solid. However, the implementation is the challenge. And our paper, which I hope you all had a chance to look at, which I think is a link. There is a link for that in the chat. Addresses some of the practical challenges faced during the DB implementation, and we suggest solutions that can be taken to potentially overcome some of these challenges. So now, myself and my colleague Richard will take a closer look at some of these challenges and some proposed solutions. I'm going to take the challenges of party sabotage, cultural bias, the lack of geographical diversity of DB members, and the lack of borrower compliance. And it may well be that some of these challenges are linked. So moving on to party sabotage, in our paper, we say that parties are not always convinced of the value added of dispute boards. But as we can see from Jeremy's presentation, there is great value to be added from dispute boards. They don't even sometimes think that they even work. And parties will actively sabotage the process by either failing to constitute a DB at the outset of a project, or even failing to constitute one at all, even if at the beginning there was the will. They did this by either indefinitely delaying a nomination of a DB member or simply deferring from nominating one at all. I recall I was on a project in the Middle East in 2009, where as a contractor, we were quite convinced that we would have a DB on, and we even went as far as nominating our DB member. But our contracting party, who was the government there, just never got around to nominating their nomination, and we just had to carry on, and we did. the parties are, and why are the parties there? Why was this done? Are the parties hoping, or were they hoping that they would be able to rely on their own ability or willingness to resolve disputes? It's clear that doesn't work, and that the DBs do work. So how can we possibly counteract the fact of party sabotage? We mentioned funders. Maybe funders can insist on the formation of standing DBs, and they encourage owners, clients, and employers to comply with their contractual obligations. And in fact, they are contractual obligations within their agreements. Possibly we can look at a pre-agreed list of dispute board members that we can agree at an early stage. And this is something that FIDIC have picked up in their 2017 editions, whereby there is a list of potential DB members nominated by both parties. The parties might want to follow the procedure where one party nominates the DB member and the other party can follow. Possibly the appointing member can push a little bit the other party to nominate. And a last resort, there could be the issue of an institute or a nominating body that will end up nominating a DB member. However, that's not always the best case scenario, because often the party members' nomination is far better and more appropriate. But overall, possibly the solution that is best is a targeted education into the benefits of dispute boards, and showing the parties that they actually do work. And as Jeremy has mentioned, maybe there's a lack of knowledge of the benefits and in the understandings of their use. So possibly one of the highest hurdles is the issue of knowledge. If I move on to cultural biases, and I have to say this hurdle can't be overemphasized or overestimated. There are cultures that simply don't want to have DBs on board. They just don't want to be told how to do things. Historically, they've had their own way of dealing with disputes. And why should someone from outside of their jurisdiction and culture come in and tell them how to do something that they've done for decades, possibly centuries? There's also a view that DBs can be a little bit condescending to some cultures. Some cultures are not acceptable. I've been involved in projects in the Middle East, in the Far East, in Africa, and there's a proud heritage and history of cultural dispute resolution. And outside interference, I use interference in a very loose way, isn't welcome, particularly in this day and age when certain jurisdictions and regions are refining their identities. If indeed there is a DB constituted, in some cultures, its decision is simply not followed, as it's not seen as a legal requirement. An arbitration award or court order is sometimes what's really needed to push things forward. Proposed solutions. Parties should be aware and have knowledge of the cultural nuances when entering into a contract. Maybe consideration could be given to traditional local dispute resolution methods, considerations from both parties. Possibly, for example, in the Japanese construction industry, they have their own sort of way of dealing with disputes, and possibly that could be taken into consideration when parties and members are dealing with disputes. Again, education to the parties needs to be provided on the benefits of having DBs on board. Maybe, possibly, perhaps culturally sensitive education that acknowledges that there are cultural differences and that these should be given consideration. So the provision of practical strategies to promote this education can be done. We can also maybe demonstrate that dispute boards, as Jeremy mentioned, can avoid the dreaded disputes in the first place. And again, we are looking at education as possibly being one of the biggest solutions in many of these challenges. Possibly in areas where parties would rather have recommendations rather than decisions. That might be a way of maybe bringing in the dispute boards. But once again, it's more often not education. It's really an important one. Closely linked to the last challenge is the possible lack of geographical diversity of DB members themselves. Can international dispute board members properly and adequately understand local cultural considerations effectively and neutrally and deal with local construction issues? This may well be the case in that someone from the outside of the region may not fully comprehend or be fully aware of the cultural nuances. International DB members may be fantastic at dealing with complex contractual matters, and there are fantastic DB members out there. And it might be that the cultural nuances are really at play here. And as I mentioned, there are fantastically talented international DB members out there. But should parties consider appointing at least one member from the region where the project's located? Obviously, maybe not the same nationality as either the parties, but someone maybe from the region itself. Parties may look at potential DB members and their experience within the region, how many projects they've worked on in that region, whether they are very aware of that region, and standing boards. The ability of a standing board to be more culturally aware is far higher than ad hoc boards. But once again, training is probably the biggest solution. Possibly better localized training for professionals within the region or country themselves on DBs and the process of DBs, so that they can also become proficient in their uses. So maybe local countries need not resort to a board full of international DB members, but maybe can be a bit more self-reliant. And finally, the lack of borrower compliance. MDBs and IFIs generally require the use of FIDIC 2017 contracts in their own mandatory particular conditions, particularly in the subclause 8.1, which states that notice of commence cannot be issued unless there's a constitution of a DAAB in accordance with subclause 21.1 and subclause 21.2. All this seems rather good. So where's the challenge, one might ask? Well, MDBs and IFIs seem rather reluctant to mandate the compliance of subclause 8.1. Hence, there is no DB in place at the offset of the project, or not at all throughout the project. So should MDBs and IFIs consider implementing the practice of refusing to disperse funds to borrowers unless and until a DB is in place? Lenders should maybe enforce mandatory nature of the use of DBs by their borrowers and also under their loan agreements. Later on, MDBs and IFAs maybe should prevent borrowers from avoiding their payment obligations following a DB ruling in the favor of a contractor or otherwise. Payments of DB rulings is a contractual obligation, and funders have got to ensure that the obligation is honored. This is the case for both parties, and they should follow this unless there's an escalation to litigation and arbitration. The consistent theme going through the recommendations for these challenges is one of education and one of promotion of the benefits of dispute boards and the effectiveness that they have, as Jeremy has indicated in the paper. And possibly that is the biggest and the best way of overcoming some of the challenges that I've quickly highlighted that we have in our paper, in order that both parties and members themselves can be better informed and more educated in the use of dispute boards, their effectiveness, and their use. I've just tried to highlight very quickly the points in the paper that I took on. My colleague Richard is going to carry on that with other parts of the paper. Thank you.
Thank you, Nabil. As you said, Richard will complement your presentation.
Yes, thank you, Fanny. And good morning and good afternoon to everyone. Well, I will be representing and presenting the point of view of the contractors. Okay, I do not pretend to represent the owners or the DB members or lawyers, whatever, just contractors. As you all know, contractors are pragmatic and their views on the system of dispute boards is pragmatic by definition. And contractors actually recognize the value of the system for the simple and obvious reasons that it is quicker than arbitration, especially when it can avoid it. And it's also less uncertain than litigation in court. So we like it. But we are not entirely happy with the present situation of the dispute board system for several reasons. The first of those reasons is cost. Statistically, as demonstrated by Jeremy, the cost of dispute boards may look more than reasonable, and there may be some truth in that. But for most contractors, and for many employers also, I guess, the cost seems expensive, especially when they compare their own daily income with the daily fees that are charged by DB members. There has been, in the past few years, a spectacular increase in the cost of DB proceedings. When we considered for a standing DB that a monthly retainer of 2,500 euros per month per member was already expensive, nowadays we commonly see those rates reach 8,000 euros for a retainer per member. And the daily fees now can reach 4,000 euros per day, not to mention the cost of luxury hotels, business class flights, etc. There is another difficulty. Before the DB is constituted, we do not know what it will cost. For this reason, it's difficult for contractors to price it and for the employer to budget it. In many cases, the cost is not anticipated at all. I must say that there is an undisputable legitimacy in the high remunerations of DB members, considering their expertise and the experience required to perform their duties. But this is also a market, and the scarcity of persons qualifying as DB members plays a role in the level of their fees. There are about 120 persons on the FIDIC list, and most of them are busy working in several DBs at the same time. Their availability is limited. I'll get back to that. These costs are a problem for contractors and for the employers, I know that, particularly in low and middle income countries and in emerging markets. Many employers cannot afford those rates. As a result, like it has been described by Nabil, either they delete all contract clauses providing for the DB, or they sabotage the system, or they prefer an ad hoc DB instead of a standing one, or they choose DB members among local professionals that are less well-known, less expensive, whose travel costs may be lower, but sometimes also less independent. And in this case, there may be a difficulty when the fees of the members in the DB are too different from one another, and they happen to know about it. This may cause some trouble. There are solutions to these difficulties. One, DB members should remain reasonable as far as fees are concerned. I know some of them who are reasonable, but I know some others who would shout at me if they heard that. More potential DB members should be identified and trained, especially in the low and middle income countries, to increase the number of persons qualified to become part of standing DBs. There should be more non-European qualified adjudicators on the FIDIC list. This is important for several reasons. One, their costs would be more attractive. Two, non-European employers would have more confidence in them. And three, there are plenty of qualified lawyers who can be appointed as DB members, but many of them have no or little practical experience of construction projects, and it's more and more difficult to find qualified engineers as DB members. Training is absolutely necessary. And good news, the development banks, and first of them, the World Bank, are pushing hard in this direction. Finally, on the cost issue, I want to mention the issue of the distribution of costs. The contractors consider that the losing party in a DB proceedings, the losing party should bear the costs of the proceedings, that the DB should be empowered to make that determination. It's not often the case. Another reason for the contractor's discomfort is the fact that in many instances, the DBs are ad hoc instead of standing. It's again a matter of cost, actually. But an ad hoc DB is a risky option. It seems less expensive, and maybe it is in the start. But when the potential conflict arises, there is in general some emergency in obtaining a solution, and the DB member or members must be up to speed. A standing DB is obviously well prepared to come up quickly and provide a solution or a recommendation, contrary to the ad hoc DB, which must be first agreed and set up with all the possibilities and occasions of technicalities which may delay or even block the system, not to mention the time required by the DB members or member to get acquainted with the project and the issues at stake. The standing DB is much safer, and there is no surprise that FIDIC has chosen this option. There is also the problem of time delays. Dispute boards are quicker than arbitration, but generally they are not really quick. Very often, the 84 days intended by FIDIC or 90 days intended by the ICC conditions are not respected, and the average duration of the proceedings is somewhere between 9 and 18 months. This is especially a problem for contractors because in most cases, they carry the burden of the costs that they claim. Many dispute board members are practicing lawyers, and quite often they are also arbitrators. They tend to handle DB proceedings as if they were conducting arbitration proceedings. This is why contractors are in favor of all modern methods that may shorten the proceedings, such as virtual meetings or hearings. Of course, this would not be true for site visits. Also, like for arbitration, we believe that the DB members should produce a statement of availability, independence, and impartiality, but they should also display the other dispute boards which they are part of. When these people are engaged in several dispute boards or arbitration proceedings at the same time, their availability is limited. It is difficult for them to find suitable dates to meet, etc. This is a serious cause for delays. Now, I'd like to come to a debate regarding what's best, decisions or recommendations. For some time, as everyone knows, the dispute boards have become dispute adjudication and avoidance boards. The avoidance of disputes is now part of their scope, and Jeremy has been explaining this very clearly. In theory, it's a wonderful idea, but the contractors are not completely enthusiastic about this. The reason is that to accomplish this new role, the DAB tends to act as a mediator and to make recommendations that may accommodate both parties. Basically, it means that the contractor should reduce its claim to obtain a partial payment from the employer. And this is not what the contractor wants. The contractor wants a quick decision, even though it may not be as good as expected. Time is of the essence. Time is money. When the dispute board is designed to issue recommendations instead of decisions, this is even worse, because either the parties have then to enter into negotiations where the contractor will eventually end up losing something, or because the employer was just refrain from applying the recommendation and do nothing in order to avoid the suspicion of corruption, a matter which is of utmost importance in many jurisdictions. Arbitration then becomes unavoidable, and the whole DB process has just been a waste of time and money. So in conclusion, we should always give preference to decision-making dispute boards and insist on the idea that dispute avoidance must remain distinct from mediation. To conclude, I would insist also on the fact that contractors love dispute boards. Most of the time, like Jeremy said, their decisions are not turned out in adjudication. So dispute board members, we love them as well. We know their capacity, experience, and professionalism. But we would like more of them, more dispute boards on more contracts. And we're glad that the development banks, FIDIC, and the DRBF are sensitive and very helpful on those matters. Thank you.
Thank you, Richard, for your pragmatic comments. We have some questions for you, also on the cost of DBs. So I will leave it to Yasmin to start the Q&A session now.
Thank you, Fanny. Indeed, very relevant. So I would like to raise the question with Richard, if possible. And I see that Jeremy already replied in writing, but let me quote the question for you, Richard. Why is cost an issue? Because ultimately only one party pays, the owner. It will suffice to include the estimated cost of DRB in the quote price. Would you like to elaborate, Richard?
Actually, it's not true that only one party pays for the cost of DBs. The price will be theoretically quoted in the contractor's proposal, and it should be reflected in the amount of the contract. But eventually, who is paying for the cost of the contract? It's the employer, and indirectly, who is paying? It's being financed by the MDBs. So it's really a significant cost. And Jeremy has demonstrated that compared to the cost of the project, it's not that expensive. But in reality, for the contractors, the cost of DBs cannot be compared to the cost of the project. It has to be compared to the cost of their margin, to the level of their margin. In percentage of the margin, the expected margin, the theoretical margin, the cost of DBs is very significant. Even though in the end, the employer is supposed to pay for the cost of the contract, the price of the contract, which is not always true, by the way. There is also always a risk that the DB decision or recommendation goes against the contractor. And as a result, the cost will be even more heavier on the contractor. So really, it's an issue. And the employers have perfectly understood that. This is why many of them continue rejecting the DB system, unfortunately.
Thank you very much for the reply, Richard. I mean, we are here for this exact brainstorming and accordingly, if possible, to provide the recommendations like you very rightfully included in the drafting of the paper as well. Any other panelists would like to comment on the cost issue, or Nabil, Jeremy?
Yeah, on the cost issue, I think Richard is very right in what he's saying. It is an issue, and possibly the costs should be, as you mentioned, compared to the margin rather than the overall project. That's a very interesting concept. But I will sort of echo a little bit of what Jeremy is saying. In the end of the day, the benefits overall of a dispute board, it's hard to not see that, and particularly in the avoidance issue, where Jeremy has very clearly demonstrated that the avoidance of disputes is possibly where contractors feel the most benefit, because when you do have a dispute going on at a time a project, you're going to have resources allocated to fighting that dispute rather than getting on with production and gaining income and revenue. So I think the costs need to be looked at in a much more sort of holistic view on the projects. But overall, I would still sort of err on the side of the fact that dispute boards are worth the cost that in the end are paid for them.
Thank you very much, Nabil. Jeremy, I think you wrote in writing. Yes. Okay. Well, quite relevant issues, and I further on the questions that are still open in the Q&A section. I have to say it's a long question, but it is something that we come across very often in our conferences. So it concerns the enforceability issue, of course. We all know that, enforceability is problematic, especially in countries where, it is not possible to actually put into execution a provisional dispute board decision. However, so in relation with enforceability, and also touched upon in the paper itself, when we say enforceability, we may not always or necessarily need the legal enforcement force. There is an equally strong, if I may say so, force by the funders, because these are funded projects. So it should be important for the funded entity, which are usually employers, to take a different standing to this enforceability issue when it comes across to the pressure of the funders. So the question goes as follows. The paper recommends procedural improvements such as standing boards from contract signing, funder oversight, and better training. But how can these measures ensure enforceability when a party resists to comply with a DAAB decision? Are better processes and funder pressure enough to make DAAB decisions swiftly complied with, or is a deeper legal or institutional reform, such as expedited arbitral enforcement, required to achieve true and timely enforceability? Who would like to give it a go? Jeremy.
Okay, I'll give it a go. I mean, there's a number of potential things that could be discussed. I think it's fair to say that the more recent contracts, so if you look at NEC4, if you look at the FIDIC 2017, they've been drafted to make enforcement potentially more effective. It's easier to enforce and it's quicker to enforce, including the potential for expedited arbitration that Yasmin mentioned. And I think really that this, plus a combination of education about the costs of arbitration. Normally, you only need to be involved in an international arbitration once to know how expensive it is, and the fact that quite often it lasts longer than the project that you're actually arguing about took to complete. And then if you think about the impact of finance charges, if you don't honour the original decision, and then that can be quite an unexpected large sum in any arbitration decision. It only has to happen once, and then you realise the merit and the importance of the role that dispute board can play. So I think combination of that and outside pressure, as the questioner said, in relation to funders, is probably more effective in the long run, certainly than any international convention might be. It's a nice idea. It's the kind of thing that lawyers would like to debate and probably will debate for a very long time. But if people don't want to comply, they're not going to comply, even if you've got an international convention. I think the pressure comes from within, and for people actually understanding the value of going with the dispute board process.
Yes, please, Risha.
Just to add a technicality on what Jeremy said, which I approve of. The problem with public owner, especially with a state, is that when the state decides not to pay its debt, it's almost impossible to force it to. There is a real big issue regarding especially investment disputes, but it's also true for other disputes. When you have a state that refuses to pay, the courts will be extremely reluctant to force it to pay. And if it does, even if it does, then the recovery of assets in foreign countries will prove extremely difficult, because even foreign courts will be very reluctant to force the seizure of foreign assets in their country. So it's really a big problem. It's especially true for investment disputes, but not only.
Maybe we can also add the question that we slightly discussed in our last roundtable in Washington. So when we say we refer to the funders' pressure, it goes both ways. So we inquired whether or not the funders, which are the financial institutions, would be willing to put the dispute board concept compliance in their rated criteria as one of their criteria for when they are deciding at the tender processes for tenderers, and at the same time for the loan owners as well, which are the employers. So it goes both ways. And in case the funders are convinced enough with this recommendation, which we may probably put in writing sometime in soon future, that would mean the real enforcement at the practical part of this whole mechanism. Although, of course, as a lawyer, the legal enforcement issue is also important, but as Jeremy said, when there is the legal provision and regulation, there is also, for enforcement, there is an equal legal provision for objection as well, so which will make the whole process very lengthy. Okay, so there are a lot of other questions, but let us have at least another two. Fanny, I think.
Yes, I had thank you, Yasmi. I had one question maybe for Jeremy, and also Nabil spoke about avoidance. The role of the GB is also to avoid the disputes. So what does it consist for DBs? Avoidance of disputes, and how do you differentiate it maybe from the role of the engineer, for instance, in FIDIC contracts? How is the DB acting differently to avoid and prevent disputes? Jeremy, Richard, Nabil. Jeremy, you want to start maybe?
That's a very, very good question. A dispute board has a different role than an engineer on the project in any event. They're not involved in the contract administration, which is a role that the engineer has. So that probably gives them a higher degree of flexibility than the engineer has. Of course, particularly in the FIDIC form of contract, FIDIC encourage the engineer to talk to the parties to try and avoid disputes when they're asked to make a determination, and that's set out in 3.7 of the new FIDIC form of contract. But the dispute board potentially can be involved before that. The whole idea of dispute avoidance or conflict avoidance is for the parties to recognize if a dispute is brewing. There's the embers of the starting point of a fire, the tap that's just started dripping, and then they can see if they can work together to avoid there being a dispute in the first place. And the difficulty when describing what dispute avoidance actually is that it will depend on the particular circumstances. Sometimes a dispute board can ask a couple of questions, and they can get the parties thinking about issues. Sometimes by asking a couple of questions, the parties realize that the dispute board understands that there is a potential dispute between them, and they actually want to resolve it without there being a formal referral. Personally, I think the key to conflict avoidance and dispute avoidance is communication. The best dispute boards, if they're a standing board which is involved on the project from the beginning, will encourage the parties to talk to one another. If you're talking to one another, you might naturally talk about issues which are issues, and then you can get a solution or resolution to them without there being any need for any formal emails and notices and claims and referrals.
If I could complement that as well, Jeremy. I think one of the issues there is that the parties also need to give the dispute board the power to be inquisitorial and to be proactive. And I think that's a very important issue from the very onset, that the parties are made aware of the dispute avoidance function that the DB can bring, and the DB is given that allowance to be proactive. And then it's the communication aspect is of course key. However, the whole bedrock of dispute avoidance, I think, it rests upon the effectiveness of the board to be able to get parties to communicate, and it's almost being a construction psychologist or psychiatrist in a way, where you have to have a certain sort of gift almost to be able to see, okay, this element needs the parties to come together and discuss this issue. And that's all well and done, but how do you get parties that are possibly heading towards a large problem to be open, be cooperative, and not begin the entrenchment issue that almost gets into play when disputes do start to become evident. So I think it's very almost very difficult for DBs to do that. However, it does really rest on the panel that are chosen. So almost it's upon the parties to look at maybe the past history of DB members and say, have they been proactive and effective at dispute avoidance? Because it's a difficult thing to achieve.
Thank you very much.
Sure.
Maybe one last question, if I may, Fanny.
Yes, sure. Yes, go ahead.
And this will go to Richard, if possible. So, Richard, you mentioned that, of course, that there is the cost issue, but there is also equally the importance of establishing a correct board. So, to that end, how you would describe the best composition of a 3-member board?
Well, it's quite easy, but this is all, again, a pragmatic view, which is based on previous experience. We consider that a good DB, the best DB, should be constituted of 3 members, preferably not 1, even though we understand that for short contracts or simple matters, like the Green Book contracts, for instance, according to FIDIC, 1 standing member should be sufficient, preferably well chosen. And we would consider that in that case, it should be a lawyer with a double background, such as a lawyer with engineering capacities. But for a classical 3-member DB, in our view, the best should be the president should be a lawyer, and the 2 other members should be engineers, so that we have all competencies in the group. The president should be a lawyer because, in the end, even though the solutions are proposed by engineers based on technical criteria. The contract is the law, okay, and the contract must be interpreted by a lawyer. So we need both competencies in the group. Again, the president should be a lawyer.
Thank you very much for the inputs. Any comments from Jeremy or Nabil?
I would very, very much echo what Rishad is saying. In my experience, have seen technical dispute boards providing very good practical solutions to problems. I'm not saying that lawyers are not competent at being dispute board members. Of course, they very much are. But as Rishad mentioned, the president or the chair is probably best suited to be a lawyer for the sake of the fact that it's going to have some legal consequence in the end of the day, the recommendation or the decision. However, very often these disputes are rooted in technical issues, and so having at least one technical professional on the panel, I think is very good for the project itself.
Yeah, I mean, speaking as a lawyer, I would actually agree with Rishad and Nabil. You want a balanced board, and you also need to be careful when you're selecting your lawyer, because you want to make sure that they actually have they're a construction professional too. They actually have proper construction experience, and that's where you need to be careful about international arbitrators. They're very good at international arbitration. They might not necessarily be the right people to be working on a project, particularly if you're on a standing board that's lasting 2 or 3 years from sort of conception to completion.
Thank you very much. All the panelists have contributed greatly to the discussion. Fanny, shall we be closing? Because I think we have exceeded slightly our time, but it was a very fruitful discussion.
Yes, thank you, Yasmin. Thank you to all the panelists and all the participants. Thank you to have joined this webinar. We look forward to seeing you again for the next episode. As Yasmin said in the beginning, we will speak about the MENA region, and we will have an update about dispute boards in this region. So we hope you can join us for the next one. We will keep you informed of the dates. And Yasmin, if you would like to give the closing words. Thank you.
Well, thank you very much, Fanny. I have nothing to add, and simply grateful for this collaboration because it has been a very fruitful 2 years, and we hope to continue our joint efforts in the soon future. Thank you very much.
Thank you. Thank you.
Bye-bye.
Very much.
Thank you.
Bye-bye.
Bye-bye.